Everyone, we are live now. Please go ahead.
Hemang sir, we are live now. Over to you.
Thank you everyone for joining our plenary session on L2 Pro. Today's topic is IP best practices for IP generation among startups and SMEs. I'm pleased to have all of you join us and especially thank our eminent speakers who joined, Dr. Vivekanand and Dinesh from USPTO. I'll just give the brief bio before we dive into the topics of discussion today. I've known Prof. Vivekanandan over the past few years. He's an eminent academic and a wonderful researcher in the area of intellectual property in India. He's the Vice Chancellor at Hidayatullah National Law University. Dr. Vivekanandan has 3 decades of teaching and research experience in legal education and has served NLS Bangalore and Nalsar Hyderabad between 1990 to 2017. He was also the dean at Rajiv Gandhi School of IP Law at IIT Kharagpur between 2009 and 10, and was the founding dean of the School of Law at the Bennett University at Greater Noida during 2017 to 19. He specializes in teaching research and advocacy of the fields of IP and internet law, and has had a wide variety of expertise. And I'm sure the startups and attendees joining today can learn a lot from Professor Vivekanandan. Thank you, sir, for joining us. We also are joined by Mr. Dinesh Sharma, who's the Senior Intellectual Property Policy Advisor at the Embassy of the United States of America, the USPTO, United States Patent and Trademark Office. He serves as the principal legal advisor on all aspects of IP rights and enforcement issues for India. And prior to joining US Embassy, he has practiced as an IP attorney, having a decade of experience in working in the field of IP. He earned his LLB degree from the Faculty of Law, University of Delhi, and also holds a master's degree in chemistry. Thank you, Dinesh, for joining us. Pleased to have you on board here today as well. Now, today's session is about L2 Pro also, and that's something, and it's an initiative which I want to share with you before we dive into our discussions with our speakers today. From a work hat perspective, like I'm the co-chair at the ASSOCHAM IPR Council, and I'm also part of the Qualcomm Design in India Challenge, where we've been incubating startups since the year 2016. And one of the things that we've seen as we incubated startups is from 2016 to today, the IP awareness has remarkably changed. We've incubated 77 plus startups so far, and we've filed for over 250 patents of their own. But in this journey of working with them, we saw a few pain points. When startups are in front of IP experts, such as Prof. Vivekanandan or, for example, Dinesh, they would get the right guidance. But what happens when these experts are not present around the startups, like in the day-to-day activities? And that's where innovation happens, right? In the startup offices. But if they don't have a guide like that at hand, sometimes it leads to missed opportunities. So we shared this pain point with DPIIT and NLU Delhi and came up with this program called as L2 Pro, which stands for Learn to Protect, Secure, and Maximize Your Innovations. It's an IP e-learning program, completely free of cost. You can avail it by visiting the website where we are sharing it here today, l2proindia.com, or you can go to your Play Store on your phone and search for L2 Pro India. L2 Pro will help startups increase their awareness in the understanding of IPR as a part of their business strategy. So how you can protect your innovations, how you can integrate IP considerations into your business models, and mostly how you can access various tools to bring these innovations quickly to market.
Hello.
So the program is split across 3 modules. I recommend every startup to be familiar with the basic level module, right? So because this will get you wide perspective on all aspects of IPR.
বনাই প্লাস বনাসৰ পৰা চাইনটো লৈ পেলাই লিটাৰখন আপোনাক দি দিলে আপোনাৰ না আমি পঠিয়াই দিম
Request you to mute yourself if you can't share. Thank you so much. Then we have an intermediate level where you get into further details of IPR, like what IP searches are, what FTO is, and so on. And then folks who are really interested, you can always go on to the advanced level where you can learn more about how IP plays an important part in getting access to funding and VCs. VC meaning venture capital. Here, how you can understand how standard setting organizations work, and of course, sometimes there can be disputes. So how can you navigate around those things? Because the course is meant as a reference material, it's presented in a very visual format, like with topics that are easy to access and understand. There are intermediate quizzes, and for each lesson, there is an introduction video, which is about 2 minutes of duration, and similarly, a summary video, similarly 2 minutes of duration. You all understand your time is a big factor, right? So in 5 minutes of investment, you can get about 70% of the course. And then later on, if you're more interested, you can, of course, go through each and every slide. Now, the folks who are interested, there are assessment modules, and the assessments are case study based. The goal is to make you practice this material, not to make you, let's say, a patent agent or a trademark agent. You can, of course, do that. However, the goal here is for you to notice that, okay, here is how I need to think about IPR. And that's why there's a case study element also, apart from factual questions. If you pass the assessment successfully, you get a certificate which is generated on the spot. Now, Bhavna already played this video when this session joined, so I will not play it here again. If you have time permitting, we can play some other lesson, some other video from a different lesson. So that brings me to the end of what L2 is. We'll share the links with you. We'll let you know again. It's completely free of cost. So startups, especially founders and CTOs, please go through this material. IP is an important element of your business strategy, right? And to know why that is the case and how we can practice the various aspects, let us hear from the experts who have joined us today. First, let me turn over to Prof. Vivekanandan. Sir, welcome and thank you for joining us. Looking forward to hearing your thoughts on how startups can follow the best practices of IPR. Sir, you're on mute.
Audible?
Yes, now you are.
Yeah. So should I begin?
Please, over to you, sir.
Yeah. Thank you. I hope the sharing screen is possible.
Yes, sir. I think it is possible because we are on a web, conference format. I think you can share, sir.
So on my screen, I see the button at the center of that dial pad panel at the bottom.
Yes, sir.
Okay. Just few seconds.
Sure.
Eh, Am I audible? No.
Sir, you were just audible and then.
Yeah, I have a problem in sharing. Doesn't matter. I can do it because about 10 minutes and then mostly are questions which are answerable. I thought it'd be easier to follow, but doesn't matter. I can go through my slides from my end. The first thing, let me first, in the first place, what I call is congratulate, the organization and other experts here for bringing this short module for startups. So let me first begin with.
आप सैटरडे गए थे 3 दिन गए संडे भी छुट्टी होती है बस
Can you please mute yourself?
क्या निकाला दूसरा
Asutami, I'm not sure if you have the admin rights to mute someone, but if you can, please take a look. Dr. Vivekanand, you might have to unmute yourself and then speak again. So we cannot hear you if you're speaking. Folks, just checking. Anirban, I can't hear anything in my end. Are you getting any audio?
No, I cannot get anything at all.
Okay.
Professor Vivekanand is having some technical issue. He is logging in and logging off, so we can go ahead with our next speaker.
Sure. Dinesh, are you okay to share your views now? Once Prof. Vivekanand can join us, we can have him on board again.
Sure, no problem.
Yes.
Good afternoon, everyone. Good afternoon, audience. And thank you very much for having me here on behalf of USPTO and Embassy. I thank everyone and congratulate SOCHM for arranging and hosting this program. It's a very important program as far as IP awareness is considered. So I'll try to be to keep it very simple, considering the subject and the impact that we are trying to achieve of this whole program. So this afternoon, I thought, let me just briefly talk about some IP considerations, because considering the topic, that the topic is generation of IP among startups and SMEs. So as we all know, and I'm sure most of the audience people are aware about this fact, that IP plays a crucial role, and we do not need to reiterate this. But yes, there is a need and constant need to disseminate awareness about IP, because it leads to positive results. It leads to generation of revenue, and there are a lot of positive results irrespective of any recipient, whether it be a startup or any other company or stakeholder. So as we all know, our economies and marketplaces are increasingly global and increasingly innovation driven. And they are powered by knowledge. We are living in an era of knowledge, creativity, and technology. And each of which is supported by and warrants IP protection. It's not just IP protection, it's the robust IP protection, I would say, that would benefit the stakeholders, the concerned stakeholders. And I do not, or I should not reiterate that IP rights can significantly support goals of startups, entrepreneurs, creators. They help transform their ideas into reality, generate income, create jobs, and make an overall positive impact on the world around them. And IP rights, patent rights in particular, or copyright also, these are vital across the industries and enterprises in today's world, in digital world to be specific. And it is well established and confirmed by various studies that contribution of IPR in economy leads to positive changes. It impacts positively. Last year, we saw this discussed extensively by the Parliamentary Committee report that was released in July 2021. It discussed extensively the impact of IP awareness, the impact of IP protection and enforcement, and the need for what exactly are the requirements that we need to put in place to make the entire ecosystem robust, that help the entire community, startups, other stakeholders. And it summarizes the discussion of other studies also. It opines that strengthening IPR in India would spur economic development by encouraging foreign exchange inflow, and which would lead to increase in productivity and generation of employment opportunities. I would say at the outset that when it comes to the importance of IP awareness, it's the overall IP culture that is very important for a business, and strengthening IP ecosystem in the country is the need of the hour. And this is where program like the instant one hosted by SHM, and thanks to Hemang and team for putting in such an important program, the role of such programs become very important. Here I would briefly talk about our role, because we are discussing and our focus is on the importance of IP awareness, leading to generation of IP amongst the startups and the ultimate benefits. That we at USPTO South Asia office, what is our role? So basically our role is threefold, and there are three pillars to be briefly speaking about our role. The first pillar is government to government interaction, which comprises of sharing best practices, monitoring development, and commenting on the regulations and rules and laws which regularly get updated because of the need of the hour in view of the technological interventions. The second pillar is to advocate on behalf of the US stakeholders to help them navigate the IP landscape here in India and South Asia. Third pillar, Gurudev to be muted. Thank you. So third pillar, which acquires very important role in today's perspective, is the IP awareness, the education. So we've been working with government agencies and industry people, industry bodies like CII, FICCI, SOCHM and all to disseminate the knowledge about IP awareness and help the audience, the stakeholders understand the importance of IP protection and enforcement that in turn help the entire economy of the country. So coming to some IP considerations, if I briefly talk about as far as the startups are considered. So I look at IP as a strategic business tool. And this is something startups have also been realizing, and they've been working on this aspect, utilizing IP as a strategic business tool. It has a very close and complementary relationship with the business, the symbiotic relationship. It protects assets, generates value to the product and stimulate the growth of the company and the economy itself. And IP overall is there to help the bottom line. And the whole purpose is to increase the revenue sources. It plays a crucial role when it comes to investment by the investors. And it is very important to understand what the investors generally look for when they decide to invest in a particular company, startup, or any other company, how big or how small it is. So they generally, and we all have seen this, there is no denying, they look for investing in a company. They look for the potential of the company or the product itself of the company. And when we talk of potential, so it may be a new invention. The second thing is they look for business competitive advantage of the product, how it is setting the particular company or the product apart from others in the market. For example, if a particular startup has conceived an invention and they have been able to obtain a patent over the concerned invention, it would give them a right for 20 years and will provide an exclusivity to help restrain the infringers from infringing the patent. So that would come as a business competitive advantage that would surely or could attract the investors. The impact of these things is the market size of share also. So they also look for this aspect, how big the market size of share is going to be of that particular company they are trying to invest in, they are contemplating about investing in. And the fourth is the commercial viability of the product itself. So generally, when you have obtained a patent, it is highly likely that commercial viability would be there. And you can capitalize on that viability. These are, to be brief, some of the points where IP naturally comes into play. And it has been seen over the years that companies who have invested at right point of time in IP assets, they have developed a portfolio, be it patent or copyright or trademark, accordingly, realizing the need and the target of that company itself. So what it does, it increases the likelihood of success. For instance, by the venture capitalist may get inclined to fund them. It would help, or it could help the probability of bankruptcy. So there are several benefits. I do not want to go too much deep into that because these are something that we all appreciate. But while considering these aspects, it is also important that time management is also of essence to realize at what point of time and what effort needs to be put in. When it comes to IP generation of amongst the startups, there are certain considerations specifically, so which we may talk about either positively or negatively. So we can talk about that there are certain typical mistakes that they committed, or we can other way around say that these are the positive things that they should remember that would help them not to make a mistake. So at the outset, I would suggest, and we all agree, that it is essential to, when it comes to IP generation and protection and enforcement, it's essential that we, as a startup, engage experienced IP attorney or an agent, rather than going yourself or deciding yourself that you would be able to deal with any scenario. So at this point, we all appreciate that startups have limited resources, and this may impact their ability to make decisions. But again, this becomes very important when it comes to the complex field of IP, particularly patents. The second thing that is very important as far as IP generation is concerned is the proper documentation. So this is, in another way, is the typical one of the mistakes that startups do, the improper documentation. And documentation is the pivot, let me tell you, around, we all appreciate the generation of IP and protection of IP. Particularly for patents, we see preserving the evidence, preserving the logbooks and all, to know when the invention was conceived, would help them to navigate the complex scenarios of litigations and prosecutions. So this is another aspect. See, and it applies to trade secrets as well, the complex field. Because trade secret is something, it's a very fact-intensive proposition. And particularly for startups, when they are engaged in the situation, when they are developing things, when they are trying to zero in on what exactly to be developed and how it is to be developed, and also right from the beginning, trade secrets are an important role. And when you, for example, are commercializing, and I'm talking about any startup or any other company, it applies to all, whatever be the size of the company. So when you are commercializing technology, IP plays a key role. Be it any business interaction, business to business, or institutions. It requires exchanging of many times information or technical knowledge that is needed to secure manufacturing, for instance, partnerships in global supply chain. So it's really a major issue. US industry talk to us all the time about the concerning lack of protection, trade secret protection, overarching and standalone protection here in India. So it makes things complicated. So it's something that I just mentioned about the parliamentary committee report. So that report itself took note of this concerning scenario where trade secret legislation is missing, where situation becomes complex, while contract law, we may appreciate it goes a long way in protecting some confidential information. But it does not solve all the problems that arises with respect to the trade secret protection. And essentially what it boils down to is how good your attorney is in drafting the contract, how watertight the agreement is that can help you navigate the scenario. You do not have a specific mechanism, specific rules, specific mechanisms to understand how to deal with the typical scenario. And this is something that startups, be it startups or any other company, face every day, each and every day in business transactions. And there are a whole lot of issues, be it data protection and every other issues, and it's a kind of field that transgresses into every IP, particularly copyright. And we've been seeing in the scenario of data protection law also the impact. So trade secret is also one of the major considerations that startups need to understand about. The another thing is considering the standard IP practices is also very important for a startup. For instance, when to file, where to file, whether there is a need to go for and just have a priority date, have a filing date by filing a provisional application so that you do not lose on time. Another consideration is the confidentiality controls that I've just covered in trade secret. Specifically, it applies to all the scenarios, but particularly it becomes important for trade secret scenarios. And having an overall IP strategy is also very important. We all know and we understand that for a startup, sometimes and many times IP takes a backseat because they have limited resources, they decide on their own, and they consider IP to be the second consideration. The prime consideration becomes how to reach the market. So this is yeah.
Dinesh, sorry, want to just give a time check? So
yeah, I'm just closing.
Thank you.
Yeah. Another consideration is to run a patent and trademark search. It's also very important, though it seems to be quite simple and very obvious scenario or proposition. But it really helps for a new startup to keep their presence in the market and to make sure they are not infringing on the rights of other companies or the other startups. So it's both ways. It is important to understand IP, not just by protecting your own invention, your own technology, your own thing, but it becomes important to understand, to realize that you are not infringing, you are not encroaching upon the other's rights. So both ways, its role becomes prominent. An IP audit, that also is one of the major considerations to help understand whether you are sitting over an IP and you are not realizing that IP. So that constant, IP audits and all regular IP audits can help you have and grab value out of that IP by protecting it and by monetizing it. So these are some of the basic considerations I wanted to touch upon at this outset. So over to Hemant.
Thank you very much, Dinesh. And I should fully agree with all the considerations that you laid out. As startups could understand, right? What Dinesh shared, a lot of nuances are there. Some are very explicit things that you have to be cognizant of, such as say IP management. Others are more nuanced, right? Like how you take care of confidentiality as you're developing very innovative products. Happy to share all this material is a part of, I would say, largely speaking, the intermediate module of the L2 Pro material, amongst the other things. But thanks so much for Dinesh for sharing your insights. We do have some questions that are coming in the chat box. We'll take them after we hear from Professor Vivekanandan. Okay, so here, let me please invite Professor Vivekanandan. So hopefully all the technical issues at your end are now at.
Thank you very much. I solved some of the glitches. I presume this
Yes.
will go on till the program without much glitches. So as I began telling that the word startup is something, everything is a startup at a point, and then it is something else different. But the problem always in life is that once you grow bigger, then you realize that I should have thought it earlier, right? And probably that is one of the big thing in life for everybody, whether business or otherwise. It was at that point of time we took it casual, and then at a later stage you see that something you have missed which you need not have. It is in this context we have to see intellectual property rights. It's always a debate. If you ask any company in the yesteryears, is in IPR division a spending division or an earning division? Naturally, marketing, business development, all are considered as the blue-eyed boys. IPR is considered as the one who's spending. Sometimes, often thought by finance people, it's a black hole, that where they are putting IPR, things like that. So the whole question is, how do you look that? You're thinking that as an expenditure or as an investment. That makes a huge difference. And probably the smarter ones who thought it is an investment stand to benefit a lot. And that is increasingly so from yesteryears of a traditional manufacturing and traditional level to a techno business era, what we are in. In fact, everything else is a techno business today. Whether you are getting some food by ordering somewhere, which comes to your home, is a techno business. So there is nothing like everything, and the way now the digital world has unfolded in education, again, what was traditionally considered as a classroom, a board and a teacher and chalk, is going to get a lot of transformation. This is not to pit one against another. But the point remains, as often they said, technology is something which you can hate or you can love, but you can't ignore. So it is a juggernaut which keeps coming. How to manage, this technology with other fallouts is always a public policy decision, depending upon, a particular country, a particular society. But the point remains, the question is, technology is a constant. From, when you're a hunter-gatherer to today, it's a constant. Whether you made a wheel, whether you made a printing press, whether you made a Flintstone, all are what you call as, it's a constant. So in that case, that is why the startups need to realize that starting ambitions are small. You ask any movie actor why he came to act, he'll say, I want to buy a motorbike. That's what he came for, movies, or to have little, proper, decent living. But they never think at a particular point of time. That's okay in a field of art, which takes you to a roller coaster. But in industry and business, it's better to be wiser about intellectual property. But at the same time, the big question, many people, I went through the questions before even this session, has been always the question about when too many things, when I'm a startup, and then where do I keep IP? Is it a priority or the last? Because I need to set up a place. There are startups which have started in coffee day and then have begun and all that stuff. And all the bigwigs today have started many things in their garage at a point of time. So where is that pull and pressure? The problem is, in that pull and pressure only you have to find the right strategy. If you are getting everything ideally in front of you, I presume that we will hate this world and will become sannyasis, right? It is the pressure and pull where we are trying to smartly see and whether we regret something which is in front of us, but we left it. In that context, I thought I'll just take about 5 minutes to share you a few slides so that we can spend more time on question. I hope my sharing works this time properly. I'm going to get the screen sharing. Is it the screen
I can
coming up?
see.
Sir.
You can see my screen?
Yes, sir.
PPT. Okay.
Yeah.
Okay. So what we are talking is monetizing of intellectual. At the end of the day, what is a startup? It is not some kind of a philosophical journey. We are really talking business, expansion, and of course, new things, and serving a lot of people, and then gaining legitimately of what your efforts are. So, in that context, if you look at it, for startups, basically, there are multiple founders or shareholders. They all come with some zeal. But a point when you're rolling it out into something else more, a kind of a organized entity, then the problem starts. The problem will be about IP rights. Frequently, the startup founders are the people who create key software, invention, or business plan. They form the core of the startup's value. Often, the founder's critical was done before incorporation of the startup. When I mean the word startup, we are talking about a legal journey from an organized thing to do. It is not about four people meeting, sitting and having in our and speaking. So it is about a legal journey into something phenomenally where you cannot even imagine where it can go. And so I'm talking about where IP is a core thing in that. So in order to get the IP rights, the founder's patentable invention, or it could be authorship like software or business plans or technical know-how, they should have a formal written agreement that transfer the IP rights from the individual founders to a corporate entity. That's very, very simple. Or rather, the philosophy behind is more you manage law, less you litigate. Less you manage law, you will end up litigation within the founders themselves. So more critically, the founders work prior to incorporation, the effective date of agreement. These are all very, very crucial. This is not something very mind-boggling. It is any decent lawyer will do that for you. But you think that lawyer will only come at a stage when I have a problem. It means, that doesn't work. So it better you have some lawyer friends, keep in good humor with them, right? They can even do it for a lesser cost to you because they know you're a startup. But to think the lawyer will only come when there is a litigation, the lawyer also can't do much about, wrangling out of that. So, for example, why you should know the story of Edward Saverin. He was the founder, one of the founder of Facebook, if you may not understand. And it is his own problem of loss of face. Why? Because when Zuckerberg and Moskowitz went and registered at later stage, Saverin had the big shock, right? They had their falling out. Zuckerberg engaged the startup lawyer in California. Facebook was incorporated. As you all know, everybody goes to Delaware because it's a tax-free thing in many ways for many corporates. Zuckerberg and he signed critical IP to the Delaware Corporation. New company and now control the most critical asset. After all, Facebook, nothing else other than IP, right? There's nothing great about it in terms of, huge creativity, but it's the IP which runs the whole show. Now you can see that how this could be a disadvantage. So the question is, you don't have to be a future Edward Saverin, right? If you want to really think in the beginning itself. What are the bases? I think my earlier speaker touched upon. I'm only trying to reiterate at least the basic four things: trademarks, trade secrets, copyrights, and patents. All of you know that if you have a logo, the name of the product, your tagline, color scheme, everything is important, including website. Please don't think these are all too casual. We see that later. Either you may be infringing someone or you might have lost it somewhere to someone. Both the things happen. You inadvertently step on somebody's shoes, or somebody pulls that below your shoes. So this is very important. And again, trade secrets, many things for startups, business plans, customer lists, source code. Don't think it's only the core source code. It could be financial data, formulas, hidden methods of doing business, right? All of this required to be properly documented, and then see which is the ideal thing to protect. Where should you go for a patent, or you like to keep a trade secret? This is not the time we can get into nitty gritty. I'm pretty sure that all of you will, many of you would have been exposed more. Some of you are startup. As far as IP subject is concerned, please, I will tell you to, be read more, listen more to this, and consult more. Then similarly, copyright, content, videos, podcasts, marketing material also matters, and then photographs, etc. Patents law again, business methods is very prominent in US. Games are prominent. You don't want to lose the territory. In many other places, it may not be there, because you all know IP is territorial, and there could be huge variation in terms of different places. One thing you should remember, IP is your fast track thing from being local to global. Manufacturing doesn't take you global. It requires many things. But IP is something where you don't need to manufacture, but still you can license and reap the benefit. So please remember, the arena is global always. It is not where you are, and that is to be understood by a startup thinking that I'm from a small town. What is global? My ambition. And then you have to only remember Abdul Kalam, who said a small ambition is a crime, right? So have a global ambition in terms of your IP. So some of the facts I'll just close in a minute. Does the company own the patentable inventions generated by the employees? That is very important, because your startup, you are starting in a very goodwill and many things, and later you find. Or does the company own all the copyright expressions of the employees? Or does the company owns all trade secrets? The answer is not necessarily. The company will have a clear title to the employee generated patentable invention only if there is a clear written agreement. Otherwise, you might end up, which might go in your way or may not be in your way. So it's better to manage law by way of smart way of writing a documents, contracts. Otherwise, as I often say that trust is a good thing, faith is a good thing, but in my opinion, law is a better thing, right? There is an Arabian proverb: believe in Allah, but don't forget to tie your camel, right? That is what I would like to put it across to you, that startups, please squeeze some time, money to do these things. Otherwise, what you thought was a great, what you call ordinary, insufficient thing could be different. So the company will own trade secret, but as long as it remains the secret, many companies don't bother about trade secret. It's very, very essential that the employee should be sensitized, right? And because the onus is on you to prove in the court that you have a trade secret and you have safeguarded it. You can't have a presumption that everybody will understand there is a trade secret. This is often. And then shop right, they call it as merely shop right. Right? If you want to scale up later, the shop right cannot be automatically transferred unless there is a proper written agreement. So I would like to just close few things which I said. Without what I said, written agreements, it falls into a lot of gray zone of IP law. Gray zone is no place for a startup. So when contracts put you in black and white, this is where the savvy startup lives. Otherwise, it's a problematic thing. Or you thought what was so common could be a problem to you. There are a few things which I thought I will tell you. Most importantly is when you are on a smaller level employment, because let me tell you, from you transcend from startup to a bigger one, there are enough law firms will be with you. They take care of things. The main things I always see in startups is their legal quotient is very, very low. And IP is nothing but a legal fencing tool of your creativity. It is not a physical tool like a manufacturing company. It is a legal fencing tool. So it's very, very natural for you to get a grip of what is around and what is feasible, what is possible, so that right you put your best foot forward, and then you are able to do this. I thought I will just give this sensitization and stop at this point and leave it to the anchor to go to the next part of the program today. Thank you.
Thank you so much, Professor. I think this is very good. Uh, I say we've received a number of questions, and it'll be great if between you and Dinesh we can answer a few of those. And we also have the opportunity to have the participants ask that directly. One question which came up by Dr. Suman Lata, and Dr. Suman, I request you to even clarify. But for the speakers, I'll just read out the question: that what are the subsequent steps for the commercialization of an already filed drug patent? So I assume the patent has not been granted yet, but there's an intent to commercialize. But Dr. Suman, if you can unmute yourself and add more details, it would help.
If I would like to comment.
Sure. Please do.
It's very simple that, as I said, that the moment you think that you are moving into a preliminary application of patent, parallelly, you need to look at transactional issues when you will license. Because remember, patent itself is 20 years. You're going to get it after a few years. And after a few years, not necessarily the invention survives the entire period, except for drug patents. Many of them, the life cycle is so fast. So the question is, from paper to currency, I call it, paper is patent document, to monetization, the speed is the only element, which means nobody stops you from doing other exercises and keeping it ready. If you're going to start having a party after publication of the patent and then go, I can only wish good luck.
Good afternoon, sir.
Yeah, please go ahead.
Good afternoon, sir. This is Dr. Richa Ori. My question was how to develop small, medium enterprises in rural areas.
Oh, come again?
How to develop a small SME industry in rural areas.
Well, see, frankly, I'm no expert on the rural area, but I had a little exposure recently in Chhattisgarh, where HNLU was asked to partner with the Bastar district, which is, Bastar district is a trouble district in many ways. So, but it
Yes.
had a lot of artisan and craftspeople. And so it was the initiative of the deputy collector there called a project called Think B, and then tried to get our HNL expertise is more on giving help in labor law, contract law, etc. So my suggestion to be, I'm pretty sure that I've been there in this field for 25 years. And currently, I will tell you, many district administrations are aware of about startups. Everybody now are trying to do something and showcase. You need to even talk to the district, because when you say rural area, in India, rural area could be so wide angle. What is a rural area in Tamil Nadu will be entirely different in a different state, or in some other place like Karnataka. So I would say district authorities is one, and I'm pretty sure ASSOCHAM and CIA could really locate some resources for you on that.
Okay, so much. Thank you.
Maybe if I can add, Dr. Ori, and for everyone else who's joining from different parts, and being on the ASSOCHAM IPR Council, I can say that ASSOCHAM has run IP facilitation centers, and they're trying to open them up in different parts. So please get in touch with the nodal officers. We have Bhavna who's here. You can email her for access.
Yeah, sure, sir. Definitely.
Right. So
Thank you so much.
Please be in touch with these people, and they will help you out. There's a question which came on the chat box recently from Ranveer Sood. Ranveer is a student of D Pharmacy from the Lala Barkharam College, district Barwala in Haryana. And I'll just read out the question if it helps. Says IP management is a tricky activity for MSMEs, because of various resources required. Now, is the government encouraging any agencies which can provide end-to-end IPR management services for MSMEs at affordable cost? Either Dinesh or Professor, if you're aware of anything, you can chime in. And
see, first of all, individuals are, if you're when you say that SME, if you're an individual, first of all, the whole costing is very, very low vis-a-vis a corporate filing. That is the first thing government is doing. And many patent facilitation cell, as you say, that they help you in free patent search, many things to do. As I told you, the simple philosophy is there is no pain, there is no gain. So, as I told you in a generic way, you need to find out within the pulls and pressures about certain things. And certain things are not a very big deal. Getting a copyright registration, vis-a-vis patent is much, much easier. And having standard templates of trade secret can be implemented. It's not a problem. And even in trademark, you are able to establish as a senior player, still you can regain. These are all not very expensive. Vis-a-vis patents could be, I understand, more nuanced and little tricky, where you have different types of services of higher end to middle level or things. So my point is, I don't have a specific answer, but I say that you have to find a way of resources on that. And many of these things, let me tell you, is lost because lack of awareness. Otherwise, it's much, much easy to do few things. That's very, very easy to do with, as Mr. Emang was telling, facilitation cell. Many of them they help. MSME ministry itself helps in a big way.
And just to add,
Sure, sir. Sure. I understand what you're saying. Thank you.
just to
Dinesh,
add
do you
on
have anything to add here?
yeah, I wanted to add a bit, if I'm allowed.
Yeah, please.
Yeah, thanks. So just to add that IP awareness again is the key here, and we all know, sir has also mentioned that initiatives are there. Government has been taking various initiatives, and just I mentioned, in my talk, parliamentary committee report also, emphasized the need for IP awareness, reaching out to the stakeholders, hand holding and all. So this is very important, and various schemes are there in various departments. But the need is to disseminate the awareness also, and also the another need is to have consistency between the policies. In India, this is something what we realize, that policies are there. The policies talk about differently, on different aspects, but lack of consistency is also again the problem, where the dissemination of awareness and the positive results, that's the problem, that do not kind of reach out to the ultimate stakeholder. So this is something that is very important to understand. So various initiatives are there. So we all need to conjointly work hard to bring awareness, to handhold, to help improve the environment. So this is something I wanted to add briefly.
Thank you. I'll pull up a question which has come from the participants earlier, and this is in the area of nanotechnology. That it's an emerging science with many applications, and in India we've had research going on various nanotech projects for a number of years. The question is, how can startups and MSMEs capitalize on that? Probably the idea or the question is, there's research being done. Are there opportunities for tech transfer? So maybe let's start with Dinesh, and then Professor Vivekanandan, if you can add your bits also on.
The point in what I'm telling, even though it sounds very futuristic or too postmodern, the word nanotechnology, end of the day, as I said, that apart from concerted efforts of big companies with R&D, there are very smaller people who also can come across. So the point is very simple. First, you need to see, when you're talking IPR, it comes post innovation for any MSME. So it is not IPR because you are motivated to IPR, not that you invent. You have innovation. How do you manage the innovation is where IPR role comes in effectively to give you the more thing. So probably, as I said, that you can approach what I call as even Professor Anil Gupta of Ahmedabad has this honeybee network of smaller thing networking, etc. And I would say that I don't know where you are and where this particular thing. Universities and institutes could be one area where you can go discuss and collaborate if you have something which on a partnership that could be developed. if you are an individual entrepreneur who are having some idea about some aspects of nanotechnology. Otherwise, it's a bit of generic question. As I said that only thing, MSMEs also can do a great contribution on nanotechnology. It's not something, it should be a Fortune 500 company which has to involve in these areas.
Excuse me, sir. Can I come in? I was the person who actually had that question. Can I clarify the question a little bit with your permission?
Please.
Thank you, sir. Actually, my question was regarding an emerging technology which has huge application. In Indian market, we already have nano-enabled products that are selling, but they are very few in number. Now, the problem I was thinking about is technology grows, progress of technology is much faster than policy making. Obviously, because technology growth and if you think about developing a regulatory policy, then you'll have to ask for the stakeholder for their opinions, and debates will go on, and it will have to be placed in the parliaments, and so it's a long drawn process. So right now we do not have as such any specific guideline for nanotechnology. We have only one guideline that is proposed by DST, which is about safe handling of nano-enabled product at the preparatory stage, not when it is being manufactured. And we have two proposals. One is on the pharmaceutical industry. Another is if the nano-enabled product is food or an agrochemical. So in this place, my question was in this background that is the absence of a specific regulatory guideline on the nano-enabled products, is it a deterrence or a boon for startups and MSMEs to plan their business strategy around nano products as a core asset?
You want my frank opinion? My frank opinion, I always found on many of these things, in fact, IT industry boomed in India when there was no IT ministry. This is not to tell ministries don't do. What I am trying to tell is, if your specific pointed question is better off, you yourself answered the question in the beginning, that regulatory things, all that takes a time, pulls and pressures of public policy is not easy. And by the time you come, the rate of technology and its curve is very faster. And then you will make it as something which may not be little outdated about or very outdated. So you need to only find out what you call as not getting into regulatory. If you're talking MSMEs are to talk, let us not forget MSMEs have many problems of finance to many things. It's better to go into some kind of handholding or a correct VC, build up can really catapult in a big way. And they will bring in you many things what is required than what I call a country of our complex size and regulatory things, etc. That's my opinion, frankly speaking. So if you have something, they always say something. If you have something worth protecting, let me tell you, everybody will flock to you. That is a big question. That is a big question. But we all think, see, we cannot, as I said, that I cannot teach as a professor how a student to be creative. Right? That the person has to be creative. Then we can talk about do's and don'ts about how to, manage and do. So that is the whole question I'm telling.
Thank you very much, sir.
Yeah.
Dinesh, over to you to respond.
I completely agree with Dr. Vivekanand. In fact, the answer was there in the question itself. So it's always been a matter of debate, whether to go for, whether to have a policy in a particular area or not. But again, what is more important is the robust policies, consistency among policies, and clarity among them. So we see just to mention a brief example or instance. The issue of ownership of IP coming out of research institutions and all has been an issue, be it any technology, and we do not have clear framework. Like for instance, we have unlike US, we have BEDOL framework. At least we have something to share and to learn from best practices and all. So it provides clear, predictable framework for retention of patent title by contractors. So we see, lack of consistency among guidelines. Like we saw one model guidelines, were evolved by the one agency of DPIIT CPAM. And we saw on the other hand, one education policy was there. So both were talking, in different directions. So what is more important in a particular area is to have consistency among policies, to have clear and predictable framework, or otherwise it's better not to have that policy, which confuses the environment and leads to, unpredictable and unreliable results. This is just brief.
Thank you, Dinesh. And thank you, Professor. I think, yeah, very actionable insights that you shared. So I'm going to wait if there's any other question, because largely what we've received from before have been addressed, by our speakers in their respective topics. Or maybe we can take one final question if there's someone who wants to ask.
Meanwhile, sir, I want to add something to the Ranbir Sood's question. He has asked that someone can assist for end-to-end IPR filing or IPR facilitation. So we at IPFC Center, IPR Facilitation Center, we used to provide facilitation services related to all the IPRs for all the startups and MSMEs. Because we are an IP facilitation center under MSME ministry, so we kind of facilitate the IPR registration, and if they get granted a patent or trademark, so if we can help them to get the expenditure reimbursed from MSME ministry as well. So that's all. Thank you.
Thank you. Clear, ma'am.
Hemang, would you like to take a question which came, which people had asked, Professor Arvinder Singh Dalal, who was the former HOD Dean of MDU Rohtak and NLU Jodhpur, he asked related to IP related foreign judgments and whether they are recognized. He said in municipal courts, but maybe he means Indian courts.
Can you come again?
Sir, he asked if IP-related judgments from foreign courts can be, what is their enforcement in India?
100%. When you're talking generically about IP-related judgments, we are really talking about what are the background issues and finer points. It's not just IP. Indian courts, all like foreign courts, also do the same, vice versa. They always are what you call as precedents from other places or taken as examples, as long as in a great way it fits a particular situation. That's very important. Generally, precedents cases are from India, but there are always foreign cases, brought in where there is no such precedent in India. That becomes a kind of a guiding factor. Or sometimes it was very finely done. It has been done. For example, the Indian case long back, the case relating to, the Maneka Gandhi's case during emergency on her passport was something widely quoted by many foreign countries. If you go and search, you will find that is quoted in many ways, right? Interestingly, what you call as some of the countries are much ahead in terms of judicial pronouncement, especially technology area. So we might have more foreign cases coming, but Indian cases are catching up where it is finely nuanced nowadays. Many of them could be, which will be quoted by other jurisdictions. I consider world over courts and judges are open to, what it means justice and what it means, a good argument anywhere.
Thank you, sir. And I think this will be a quite open question between you and Dinesh. It's around IPR aspects for cryptocurrency. So the original question is for can we take IPR for cryptocurrency coin projects with the goal of local grassroots level problems and sustainable goals for India and abroad? I think the question is fairly broad, but what are the IPR aspects which apply to cryptocurrency?
Can you come back on the last part? I couldn't hear.
So the part about India and abroad is filing, protecting the IPR, across geographies, across the globe. I think the unique aspect which applies to this cryptocurrency coin projects seems to be sustainable development, and that it's come from the grassroots, local level problems. I'll admit I don't know too much about cryptocurrency.
Is it listed in the thing, or is it?
It's in the chat box. Let me paste it for you. And if Achila Paripuram company, if you can unmute and ask, maybe that's better also.
No, my problem is your voice a bit cracking for me. So is it listed in the questions, or is it outside?
Please refer to the latest message on the chat box.
Question number?
Sir, the last one, sir.
Okay, got it. Let me read, because Mr. Hemang's voice is little down and it's coming. So last one.
Yeah.
The last one you're telling, that is 17, question number 17.
No. This is
it is on the chat box. Sir, Hemang, should I just try and repeat, sir?
Your voice is little clearer to me.
Okay, sir. So they are asking whether they can, can we take IPO for cryptocurrency coin project with the goal of local grassroots problems and global sustainable development goals? I think, sir, I mean, like relation, I mean, in the sense the IPR issue related to cryptocurrency, sir, if you can speak, if you have, if you.
Okay, see, one is that you're talking about cryptocurrency itself has been debated whether it's a sovereign currency or is it a privately held pre-nation state, pre-nationalized banks, people who are bartering and people are doing. So still it is very policy level, all are watching and waiting to see whether sometimes they have a proverb, what they say, if you can't beat them, join them, right? So that could be one approach, what governments are doing. But we are looking at IP issue of cryptocurrency. Again, it will boil down to any one of the elements of copyright, what type of blockchain is used. All IP will come as it is. The word techno jargon which we are using is the word cryptocurrency, right? So there's two parts to the story. One is it a legitimate kind of currency which nation states are going to embrace in a big way? There are indicators here and there, even in this budget when they talked about taxing it. But at the same time, there'll be a wait and watch policy about fully how this is there and how far it is going to, is it only a little very elite level of, currency game? All these things are going to, wait and watch situation. As far as IP, I consider same, whatever you use in terms of software, in terms of blockchain, in terms of many things which are fundamental to cryptocurrency, the relevant IP will come into place.
Sure, sir.
There is not going to be a new IP segment going to be invented for cryptocurrency.
Yeah.
Dinesh, would you have any view on
Yeah, just to add to what Sir has mentioned. So I completely agree that this continues to be, an evolving field. It's still at an nascent stage. So it would not be appropriate to comment too much on this area. But again, blockchain, in terms of blockchain technology, it has been a game changer for both like US and international. And particularly when we talk about trade secrets, so it like blockchain provides, we could consider it like an efficient and cost-effective mechanism for protecting trade secrets in terms of litigation and all, because there are aspects like ownership is there and existence. You need to prove existence also, notice and access. So these blockchain evidence can be accessible. So there are users, but again it is still at an infant stage, and now we are getting NFTs. It is too premature to comment on these aspects, but they have larger roles to play in future. Thank you.
Thanks much. I think we are at the end of our session. here today. We received very good insights from our speakers. So thank you, Professor Vivekanandan. Thank you, Dinesh, for sharing these insights with us. Special thanks to all the attendees who joined us today. Your active participation made this a very lively session. So thanks much, everyone. And again, big thanks to the ASSOCHAM team for a wonderful job in organizing this session. Thank you all. I convey sincere thanks on our behalf. Thanks Anand as well. Okay. We bring this program to a close. So yeah, see you all later. Thank you.
Stay tuned. One summary video is there.
Bhavna, you can just play that. And I think folks are also asking for the feedback link.
Thank you.
Thank you, sir.
Let's do
Thank you,
a
Professor.
very quick recap. It is important that entrepreneurs are aware of any existing inventions or marks which may be similar to theirs. That is where patent and trademark searches come in. There are a number of patent and trademark search tools available which you can use for this purpose. Now comes the process of patent search. INPASS is the Indian Patent Office's search tool. It allows you to conduct full text search for granted patents and published patent applications. You can customize the search results using different keywords and search terms. The WIPO Patent Scope database contains data from 52 patent offices across the world, including the Indian Patent Office. The European Patent Office, EPO, also offers a free search tool where you can search for patent publications in a database of 100 million patent documents. Free Patents Online is a free database which allows you to make a search of the various patent search databases. The next step after a patent search is to analyze the search results. Qualified patent attorneys can assist you in conducting these searches, analyzing the search results, and making appropriate decisions on protecting your technology. You can access a list of patent facilitators empaneled by the Government of India in our practical information section. Coming to trademarks, it is a wise practice to conduct a search in the local and international trademark databases before applying for registration. This is to make sure that there are no conflicting marks which may hinder the acceptance and registration of your trademark. The website of the Ministry of Corporate Affairs allows you to search a company name in their database. It also provides a search facility for domain names where you can search for available .in domain names at the Government of India website. The public search facility available on the website of the Trademark Registry allows you to search for word marks in different classes. Since there is no image search option available, the scope of the search is limited. But you can still have useful insights on existing identical or similar word marks and also have any device marks, images consisting of those identical or similar marks. Using WIPO's Global Brand Database, you can search for trademarks which have been registered under the International Madrid system. Note that the International Search tool is not a substitute for a trademark search in the national IP offices. Instead, an international search should be used in combination with the search of the national IP office databases. We have learned quite a bit about patents. Let's get a quick recap of the key takeaways. There are 8 categories of IP in India: patents, trademarks, copyright, industrial design, geographical indications, plant variety protection, layout designs of integrated circuits, and trade secrets and confidential information. Remember that IPRs protect intangible property. Since IP is a critical asset for your business, there should be a sound IP strategy in place which helps you in creating, managing, and enforcing your IP. It can be offensive as well as defensive. Let's look at patents now. Patents are exclusive rights given to the inventors of an invention. The right holder is called a patentee. A patentee can transfer the patent, claim ownership on it, prevent its unauthorized use. Your patent will last for 20 years from the date of filing. In India, you can get a patent for an invention if it fulfills the patentability criteria of novelty, inventive step, and industrial applicability. But there are certain inventions which will not get you a patent. You can find a list of such inventions in Section 3 and 4 of the Patents Act. Written disclosure is mandatory to get a patent. Once you get a patent, you also need to maintain it by paying a yearly renewal fee. Remember that patents are territorial in nature. This means that every country grants its own patents. For patent protection in multiple countries, you can file an application under the International Filing System, which is the Patent Cooperation Treaty, PCT. The Indian government, realizing the importance of IP for startups, launched a scheme to promote IP filing by startups. Here, startups get huge rebates in patent and trademark filing fee and can also apply for faster examination of their patent applications. There are also government-recognized trademark, patent and design facilitators to help you with the filing process. The best part is that you only need to pay the government filing fee, and the government will take care of the professional fee of the facilitator.
Whosoever is asking for this informative PPT, just register on L2 Pro India website, and this all will be at your end too. So you can register on L2 Pro India and learn all the tools from that IP learning platform. Thank you for joining in.
Thanks.
Yeah, thank you all.
Thanks audience for your engagement on this webinar. And we have our social media tools on LinkedIn, Twitter. You can always send a message to us.
Thank you, ma'am.
Thanks. Okay, we can close the webinar now.
Yes, sir. We'll close now.